witness as to the previous statement made by him in writing or reduced into writing, and if it was intended to contradict him in writing, his attention must be drawn. Call to the those portions which are to be used for the purpose of contradiction. Section 161 deals with the adverse part. It is an ROP. The adverse part is right as to the writing used to refresh memory. It can therefore be seen that the right of the accused to cross-examine the police officer, which reference to the entries in the police diary, is very much limited in the extent and even that limited scope arises only when the court uses the entries to contradict the police officer when the police officer uses for refreshing his memory. In other words, in case if the court does not use such entries for the purpose of contradicting the police officer, or if the police officer does not use the same for refreshing his memory, then the question of the accused getting the right to use the entries even to that limited extent does not arise. The accused person cannot force the police officer to refresh his memory during his examination in the court by referring to entries in the police diary. એટલે પેરાગ્રાફ 11 આપણને લાગુ નહીં પડતો કારણ કે એ હકીકત ઊભી નહીં થાય. 12 section 145 the evidence act consists of two links. It provides in the first link section 145 that a witness will be cross-examined as to the previous statement made by him without such writing is shown to him. But the second link provides that if it is intended to contradict him by writing, his attention must before writing can be called on those part of it which are to be used for the purpose of contradicting him. Section 155(3) and 145 the evidence act deals with different aspects of the same matter and should therefore be read together. Be that is made. As the mentioned sutra, right of the accused to cross-examine the police officer with reference to the entries the police diary is very much limited in the extent and even that limited scope arises only when the court uses the same entry to contradict the police officer or when the police officer uses it for refreshing his memory, and that again is subject to provision of section 145 and 161 of the evidence act. Thus, a witness will be cross-examined as to previous statement made by him as contemplated in section 145 of the evidence act if such previous statements are brought on record in accordance with law before the court, and if the contingencies as contemplated under section 173 are fulfilled. Section 145 of the evidence act does not either explain or control the provision of 173. We may accentuate that here itself there is no scope in section 172 CRPC to enable the court the prosecution of the accused police diary for the purpose of contradicting any witness other than the police officer who made it. First, I have Supreme Court to judgment and make it. This has in my humble submission, when the memory is refreshed, the accused is entitled to the copy of the same. And બીજું જે judgment છે શાંતિલાલ નું જસ્ટિસ પાટીલ તેના અંદર બી સાહેબ સેમ હોય છે. એમાં બી સાહેબ બધા આગળના સુપ્રીમ કોર્ટના જજમેન્ટને કન્સિડર કરી સાહેબ એમાં સેમ જ વસ્તુ શેર કરેલી છે. Therefore, my application will kindly allow. Single witness hostile contradiction of issue. જ્યાં સુધી એમને લાગે વળગે છે કેસ જોવા માટે એમણે જે સાંકળી હતી અદાલતમાંથી એમને રજૂ કરાવી દીધી છે. હવે સાહેબ આખી ચાર્જશીટના જે વિટનેસીસ અને ડોક્યુમેન્ટ્સ કોર્ટમાં રજૂ થઈ ગયા છે એની પર એમની ઉગડ થઈ ગઈ. નવું કે કેસ ડાયરીમાંથી મળવા પાત્ર નથી એમને. એટલે સાહેબ કેસ ડાયરી લઈ અને સાહેબ એની ક્રોસ કરવી બેટર છે, ક્રોસ કરી લે નહીં આપવાના આપણા અંદર નથી પણ સાહેબ એની સાથે રિલેટેડ હોય કેસના મેરેજ જો એવું કહી છે અત્યારે હાલના તબક્કે અહીંયા દેખાતું નથી. સુપ્રીમ કોર્ટ નો ઓર્ડર છે વાત સાચી છે, આપણે મનમાં બંધાય કેમ કે એમનો રાઈટ છે પણ સાહેબ કેસ ડાયરી લઈ અને સાહેબ પછી એ ક્રોસ કરશે. ઓલરેડી એમની ઉલટ તપાસ શરૂ થઈ એટલે સાહેબ આ તબક્કે એમની અરજીને સાહેબ ગાયબ રાખવાની જરૂરિયાત નથી.
તો કેસ ડાયરી રેકોર્ડમાં રજૂ કરી છે
અમે જોયું છે મેમરી આપ નામદારના કરી શકું એમને જોવાની અમે એવું ના નહીં પાડી શકીએ. મેં હું એવું નહીં કહું કે નહીં કરે પણ સાહેબ હાલના તબક્કે આ કેસને રિલેટેડ છે જરૂર નથી એટલા.
બરાબર એમ કોઈ પર્ટિક્યુલર એન્ટ્રી એને રિફર કરેલી નથી,
ના સર,
જનરલ છે ને.
વાત સાચી છે
એટલે
સર.
આ જજમેન્ટ છે એ પર્ટિક્યુલર એન્ટ્રી માટેનું છે, તમે જે રજૂ કર્યું ને એ.
ના સર, એના અંદર એવું છે
સારું.
કે આપણે એક જ મિનિટ સર, 159 જોવામાં આવો એ તો સાહેબ સાચી જ વાત છે, હું ના નહીં પાડું. પર્ટિક્યુલર સ્ટેટમેન્ટ પૂરતું હોય, કોન્ટ્રાડિક્શન પૂરતું પોલીસ ડાયરી જોવા
બાકી તમને કોઈ there is no right to accuse to refer the case diary.
હવે સાહેબ આપ જોશો 159 હું સાહેબ 2 મિનિટ જ વધારે લો. રિફ્રેશિંગ મેમરી, a witness may while under examination refresh his memory by referring to any writing made by him at the time of transaction covering which is question. એટલે જે તે વખતે જે બનાવેલી આ કેસ ડાયરી question, so or so soon afterward that the court consider it likely that the transaction was at the time fresh in his memory. The witness may also refer to any such writing made by any other person and read by the witness within the time aforesaid if he read it he knew it to be correct. પછી આગળ છે, when the witness may use copy of the document to refresh memory. Whenever a witness may refresh his memory by reference to any document, he may with the permission of the court refer to copy of such document, provided the court is satisfied there is sufficient reason so and so. એટલે 159 માં ખાલી એ જોઈ અને જુબાની આપી છે. એનાથી એમને આપણા કેસમાં અંદર કશું જોયું નહીં. એમને શું કીધું કે મેં કેસ આખી કેસ ડાયરી જોઈને લખ્યું સાહેબ. મેં ક્રોસમાં પૂછ્યું અને મેં આખી કેસ ડાયરી જોઈ આ નોટ બનાવી છે. જો એમને એ કીધું હોય કે આટલા પૂરતું હતું તો યોર ઓનર ઇઝ રાઈટ, તો મને આઈ એમ એન્ટાઇટલ્ડ ટુ ઓન્લી ધેટ પાર્ટ. હવે 161 જોવામાં આવે, જે નામદાર કોર્ટ સુપ્રીમ કોર્ટના અંદર કીધેલું છે, right of the adverse party as to the writing used to replace memory. એના પહેલા સાહેબ 160 is also important. Testimony to facts stated in document in section 159. A witness may also testify to facts mentioned in any such document as mentioned in section 159. એટલે ટેસ્ટિમોની એટલે એમને બધા ડોક્યુમેન્ટ રિફર કરી ટેસ્ટિમોની આપી, એ તો મને આપેલા છે, એટલે એનો સાહેબ કોઈ ડિસ્પ્યુટ નહીં. હવે આગળ 161, રાઇટ ઓફ એડવર્સ પાર્ટી એઝ ટુ ધ રાઇટિંગ યુઝ ટુ રિપ્લેસ મેમરી. જો રિફ્રેશ મેમરી કરવા માટે રાઇટિંગ યુઝ કર્યું હોય તો એડવર્સ પાર્ટીના શું અધિકાર? એની રાઇટિંગ રેફર ટુ અંડર ધ પ્રોવિઝન ઓફ ધ લાસ્ટ ટુ પ્રિસીડિંગ સેક્શન્સ, એટલે 159 ને 160 છે, must be produced and shown to the adverse party if he requires it. Such party may, if he pleases, cross-examine the witness thereupon. એટલે એમને આખી કેસ ડાયરી જો રિલાય કરી નોટ બનાવી, નોટની તો આર્ટિફિક પડ્યો હોય તો I can't be denied copy of that case diary, sir. That is my submission.
એને બોલાવી લખાવી દે છે. Evidence to
આપું છે ને
ના છે આ એક્ઝિબિટ કેટલા આવે છે મેમ?
570.
Order below exhibit, order below application exhibit 570 in session case number 187 of 2017 with session case number 192 of 2017 with session case number 194 of 2017. Paragraph. The learned advocate of the accused number 1 filed this application under the provisions of section 172 into bracket 3 of the Code of Criminal Procedure 1973, read with section 154, 161 of the Indian Evidence Act 1872. બરાબર રાજુભાઈ, આ તમારે કેવું પડે બધું, આ તમારા આ વિષય તમારો મારો 1872 for giving copy of the case diary to the accused. Paragraph. The short breadth of the application is under the accused number 1. On behalf of the accused number 1, state that the prosecution witness investigation officer PW49, namely Kesavlal Premjibhai Gajipura, is going on. The said witness is the main investigation officer who had conducted the investigation. થોડુંક રહી ગયું પણ હવે મારામાં લઈ લઈશ. ઓલ્સો ફાઇલ ધી ચાર્જ શીટ. રહી ગયું, હું મારામાં લઈ લઉં છું. હા બસ. પેરેગ્રાફ ફર્ધર સ્ટેટ that PW49 has given the evidence by referring to the note prepared by him. The objection was taken by the accused. The said objection had been overruled. And the examination in chief was completed. Paragraph. Further state that the accused on behalf further state that during the cross-examination of PW49 had admitted that he has prepared the notes for giving the evidence by referring to the case diary. And said not be exhibited number 567 and 567. Paragraphs. Further state that the accused is entitled to the copy of the case diary as per the provision of section 172 into bracket 3 of the CRPC for exercising the right under section 145 and 161 of the Indian Evidence Act. And reproduce the said provisions. Further state that the police officer has used the case diary to refresh his memory, and the accused is entitled to a copy of the case diary. and required to contradict it, and therefore also the accused is entitled to copy of the case diary for cross-examination. Paragraph. Further refer the judgments of Honorable Supreme Court and Honorable High Court as under para 9. And lastly, prayer nothing. Yeah, great that chalo. The case diary is required to be produced before this honorable court, and it is to be shown to the accused and copy be given to the accused for the purpose of cross-examination of the prosecution witness number 29. Paragraph. Urge the learned advocate of the accused and learned special public prosecutor at length on facts and provisions of law. Paragraph. Learned advocate of the accused number 1 submitted the at length facts and reiterated facts as per the applications. Further submitted the para 10, 12 of the judgment of Honorable Supreme Court in case of Balakram versus State of Uttarakhand, reported in 2017 into bracket 7 SCC page 668, and also relied the judgment of Honorable High Court. Paragraph. The learned advocate further submitted the apparent facts of the provisions of section 172 into bracket 3 of CRPC, section 159, 145 and 161 of the Indian Evidence Act. And lastly, played to allow this application in interest of justice. Pre contra, the learned special public prosecutor submitted the headline facts of the application and vehemently argued that the case diary is already produced on record. Further submitted that during the trial, not a single prosecution witness has been hostile and not required to refer the police statement or the Panchnama to contradict the prosecution witnesses. Further submitted that the defense side have no right to refer the case diary, and lastly prayed to reject this application. Paragraph. I have gone through the application. Consider the advance arguments of the learned advocates of concerned parties. Also consider the judgments submitted by the learned advocate of Case number 1, paragraph. The learned advocate of the case number 1 filed this application under the provisions of section 172 into bracket 3, hence required to reproduce the provision as under paragraph. Consider the above provision actually masih 172 aktif 172 section 172 consider the above provisions neither the accused nor his agents shall be entitled to call for such diaries nor shall he or they be entitled to see them merely because they are referred to by the court. But if they were used by the police officer who made them to refresh his memory, or if the court used them for the purpose of contradicting such police officer, the provision of section 161 or section 145, as the case may be, of the Indian Evidence Act shall apply. Whereas considering the facts and circumstances of the subject matter, the PROCEEDINGS 49 investigation officer prepared a notes from the case diary and that documentary evidence are exhibited number 567 and 568. The investigation officer has not referred the particular entry. In other words, not deposed the date-wise event of the investigation. In such a circumstances, it cannot be said that the prosecution witness investigation officer referred the case diary during his deposition in examination of in chief paragraph. Consider the facts and circumstances of the subject matter and the judgments of the Honorable Apex Court in para court in case of para 10 and para 12. pass the following final order in interest of justice. The present application is hereby rejected with the clarification that the defense side, the learned advocate of the defendant, learned advocate of the accused number one, can use the particular, can use and refer the particular entry of the case diary during the cross-examination of the PW 49. તમારી પાસે જે ઓલું છે એમાંથી જોઈ લેજો, તમને જે યોગ્ય લાગે કે આ મારે રિફર કરવું છે, રિફર કરો, આપીશ. આખે આખી કોપી ન આપવું. કેસ ડાયરી.
પણ આવો પ્રશ્ન એક જ છે સર કે એ વેરીફાઈ કઈ રીતે કરી
એ તો કહું છું કે એને નથી કર્યું, એ જ મેં લખાયું કે ડેટ વાઇઝ એને કોઈ ડિપોઝિશન જ નથી આપી. ડેટ વાઇઝ આપી હોય ને તો
Date was deposited through, on the contrary, there is no any contradictory evidence in the record, there is no any hostile witness there.
ડેટ વાઇઝ એને કર્યું હોય ને કે આ તારીખે મેં આ